Okay, so welcome everybody. This is the first of our series of Global Tax Symposium seminars. Some of you, I think, might be aware of the Global Tax Symposium that was started about 3 years ago. Am I right, Eduardo? Really the brainchild of Eduardo and colleagues in various other universities. You can see that now expanding around the world, not to exclude people at any other universities, let me be clear, but just to kind of have some sort of geographic spread for the collection of research and international tax debates. So we started with an annual symposium, which initially mostly face-to-face with some people online. Of course, we moved online in the last couple of years. So the symposium this year is being hosted by India, Symposium Tandon. That will be at the beginning of December. And it will be online again. We're trying to get a kind of global coverage. There is also a PhD event, which is being hosted at McGill University by Alison Christians in September, which I think will be a hybrid event this year. She's hoping to have some people at McGill and then people online. And then just because, you know, we need to build a global empire, that's what it's all about. Now we have a seminar series. If we think the field could never be too crowded, right, in terms of international tax activities. And so for my sins, I agreed to host the first year of the Global Tax Symposium seminar series. And this is the first one of those. So we hope to have a few, probably 4 or 5 this year, as I'm really delighted that Eduardo Baistrocchi was willing to be our first seminar presenter with the research paper, and that we have Tsilly Dagan as our illustrious discussant. I can announce that I have set a date for our next seminar, which will be the 6th of June. And it will be Symposium Tandon and Hayden Water-Boris, who is here with us. So each of them are actually going to present on the topic of Pillar 2 papers from different perspectives, the inclusive framework consensus Pillar 2. Hayden doing his PhD currently on the topic, and Symposium having been writing papers about that from an Indian perspective. So that promises to be a very interesting discussion, and I'll keep you informed about future seminars. I should say, which is something we would always say here in Australia, that I'm speaking to, and I'd like to acknowledge the traditional owners of the land on which I'm speaking to you from, which is Melbourne. So this is the lands of the Wurundjeri peoples of the Kulin Nation here in Australia, and pay my respects to their elders past, present, and emerging, and acknowledge that the land was never ceded, sovereignty was never ceded. So having done that introduction, let me briefly introduce our speakers, and then we've got a forum where we have Eduardo I have some slides. We have the written paper as well. Now, I'm actually not sure if we circulated the written paper to everybody ahead of time. People are shaking their heads. So what I might do is see if I can do that in the background when Eduardo starts. Tsilly has obviously had the paper. So Eduardo will have about 30 minutes to present, and Tsilly 10 to 15 for discussion. And then we will just have a kind of general Q&A and discussion for about half an hour or so. So let me stop sharing, and I'm going to let Eduardo share his screen. And while you're doing that, let me introduce you both. Eduardo is probably well known to many people as Associate Professor of Law at the London School of Economics, who has been working in international tax law and theory for quite a long period of time. He's also an excellent host. So if you get a chance to visit at LSE while he's there, please take advantage, which I did manage to do just before the pandemic. Of course, Eduardo, being a global person, is not currently in London. He's in Argentina, which actually I didn't realize, but luckily it's not the middle of the night for him. He's studied law at Universidad de Buenos Aires and has been at Harvard Law School and then at LSE, has been a Fulbright scholar, a Chevening scholar, a distinguished visiting professor at many universities and published in many leading journals and books. And his research always brings an interdisciplinary approach to international tax and the international tax regime, including applying theories of game theory and public choice theory. And he currently, as you will see in this paper, looking at networks and how multi-sided networks operate and how this might apply. So very interesting set of theory. Professor Dagan, I'm sure doesn't need an introduction, currently Professor of Taxation Law at the University of Oxford, and previously from Israel. I guess, Tsilly, are you in Israel yourself at the moment? Probably you are, I guess.
I am, yes, this weekend.
Yes. So also a truly international person. Her book that I think is probably known by everybody has a huge impact, International Tax Policy Between Competition and Cooperation, from 2017. And I know she's further developing that work in terms of the way countries engage with each other and the effects of international tax competition on the tax community and the tax state. So she's also familiar with economic language and theory, and a very good, including network theory, and an excellent commentator for this paper. So Eduardo, let me hand over to you, and your time starts now. If people do think of questions while the seminar is proceeding, please put them in the chat. I'll keep an eye on it. Otherwise, there'll be an opportunity after the presentation. Thanks.
Thank you very much, Miranda. Thank you very much, Tsilly, for this wonderful opportunity of presenting this paper today. So as you know, it's entitled Global Tax Hubs, Theory and Evidence. And what I would like to do is to organize my words as follows. I would like to, first of all, start by stating which is the mission of this paper and the two research questions I aim to answer. Then, which is the fundamental assumption I'm making on the international tax regime. Then the methodology I am using in order to answer these two research questions. Then I would like to outline the theory, identify the 5 findings of the empirical work grounding my theory. And in the conclusion, I would like to fundamentally argue that global tax hubs are like the Ubers of the international tax regime, particularly since the United States of America and the United Kingdom introduced the check-the-box regulations in 1997 and 2013, respectively. And finally, I would like to outline some potential policy implications of this theory on the new international tax regime. So let's start with the mission of this paper, at least what I expect from this paper. I think global tax hubs are the black boxes of the international tax regime, the driving forces of their strategic interaction with other building blocks of the ITR, and their impact on the ITR stability have been, I think, unexplored from a network market perspective. This paper aims to start filling this gap in the literature by offering what I think is the first available theory of global tax hubs as a network market. In terms of the research questions, which are the couple of questions that I aim to answer today, they are the following. Can the theory of two-sided platforms explain a core business model of global tax hubs? As we will see, this concept of two-sided platform was invented by a French economist who eventually received the Nobel Prize in Economics for this very invention. So what I'm trying to do here is to try to expand the application of this concept to try to better understand the role of tax hubs. And the second and final question is the following. If so, can the two-sided platform business model explain the disruptive impact of the global tax hub market on the ITR stability? Good. In terms of assumptions, I'm making a quite striking assumption here that I plan to develop in a book I'm writing. And the assumption is the following. The conceptual framework of this paper is grounded on the assumption that the international tax regime has been the product of the strategic interaction between three oligopolies since its emergence in the 20s. These oligopolies are the following: market jurisdictions such as the US and China, MNEs such as Apple, and tax hubs such as the Netherlands. So I'm trying to offer a graphic representation of this assumption. So I think the international tax regime is here, and I think it is the product of the strategic interaction between these three oligopolies. And this never-ending negotiation between these three oligopolies is implementing in the context of external shocks such as global power shift. This paper focuses on one of the three oligopolies, which is the market of tax hubs that is located here. What I would like to add is that in tragic times, in very difficult times for humanity, such as the current time, what I can see is that there is a fourth one-day oligopoly, and that it is normally implemented, I think, by tax NGOs, for example, Tax Justice Network. And this fourth oligopoly has suggested the country-by-country reporting to the three oligopolies, and the three oligopolies have accepted this innovative regulation, and now it is already part of the international tax regime as I think of a contribution, of a proposal made by this four one-day oligopoly. In terms of methodology, in order to answer these the two research questions, the paper uses a proxy grounded on the strategic interaction between G20 countries and non-G20 hubs in tax treaty disputes. It is based on a new data set covering all 488 leading tax treaty cases decided by G20 courts, typically involving intermediate entities located in non-G20 hubs. And what this paper is doing is to classify all these leading tax treaty cases according to this global taxonomy of tax treaty disputes. These are all the patterns of tax treaty disputes I am aware of. They are, 116 patterns of disputes. I have divided these patterns into three groups. The green disputes are related to definitional articles of the OECD model, such as Article 5 of the OECD model that defines, as you know, the PE concept. The brown type of disputes are related to substantive articles of the OECD model, such as Article 9 on transfer pricing. And finally, the blue type of disputes are those related to procedural articles of the OECD model, for example, the article on maps. The idea here is to try to understand the evolution of tax treaty disputes over a period of 50 years in the search for patterns. I think now it is time to define the two-sided platform concept. It was discovered, as I said, by Jean Tirole, a French economist, and he eventually received a Nobel Prize in Economics for this invention. A two-sided platform aims to minimize transaction costs between platform users who can benefit from coming together, permitting value-creating exchanges to take place that would not otherwise occur. the core role of a two-sided platform is to enable parties to realize gains from interactions by reducing transaction costs. Two-sided platforms are frequent in all economy industries, like those based on advertising-supported media, and new economy industries, such as those based on web portals like Uber. So this is a graphic representation of the two-sided platform structure of Uber. Uber is here. It has this, it's a digital platform that fundamentally matches users on both sides of the platform. On side one are car drivers, and on side two are passengers. And this platform, the Uber platform, fundamentally minimizes transaction costs in order to match car drivers with passengers. And based on feedback from actual and potential car drivers and passengers, Uber is able to improve the platform on an ongoing basis. It is possible to see competition at the platform level. For example, Uber is competing with Didi in China. So a given car driver or passenger may choose one platform or the other. It is not possible to use both platforms at the same time. It is also possible to see same-side network effects and cross-side network effect. An example of a cross-side network effect would be the following. The more car drivers are on side one, more passengers would be willing to use the Uber platform in order to move from one point of the city to another. Good. Now it is time to see potential applications of the two-sided platform concept to the tax hub market. And I think it is possible. So here is a tax hub, let's say Mauritius. Users on side one are multinational enterprises that are willing to find the best available location where to invest, which is the best available tax hub to do it in order to minimize the effective tax rate. And on side two are market jurisdictions such as India that might be willing to negotiate their tax liability with MNEs in order to maximize attraction of capital. And this tax hub is competing with other tax hubs. And as we will see, since the 90s, tax hubs seem to be willing to do joint ventures with other tax hubs in order to offer their services to MNEs and countries, market jurisdictions. In terms of what I understand by tax hub in this paper, this is my definition. This paper defines tax hubs as non-G20 jurisdictions that meet the following test. First, they have a total inward foreign direct investment position above 100% of GDP in any decade from the 60s to the 2020. So here I am assuming that this ratio of FDI vis-a-vis GDP suggests that these jurisdictions are being used as stepping stones to get into market jurisdictions. And the second requirement is that these jurisdictions have been involved in at least 2 leading tax treaty cases with at least one G20 country from this period of time. Here I am assuming that market jurisdictions are litigating against tax hubs in order to make a redistribution of the tax rent between tax hubs and market jurisdictions. That's the assumption that grounds the second element. And a concrete example of a tax hub can be seen in the Andolan case decided by the Indian Supreme Court a few years ago. Here, a number of OECD multinationals use Mauritius as a gateway to India as a market jurisdiction. And based on the feedback from MNEs and market jurisdictions, presumably Mauritius has been able to further improve its platform in order to maximize the attraction of FDI willing to invest in India. What is really illuminating is what the Supreme Court of India said in order to justify this tax treaty shopping of the Indo-Mauritius Treaty as a gateway to India. The Supreme Court of India said the following: developing countries need foreign investment, and the treaty shopping opportunities can be an additional factor to attract them. India has been the beneficiary of significant funds through the Mauritius conduit. And here the Supreme Court makes a cost-benefit analysis. The developing countries allow treaty shopping to encourage capital and technology inflows. The loss of revenue could be insignificant compared to the other non-tax benefit to their economy. Treaty shopping is perhaps regarded in contemporary thinking as a necessary evil in a developing country. As we will see, all fundamental elements of any two-sided platform are somehow visible in this couple of paragraphs of the Supreme Court of India decision in the underlying case. Another example of the application of a tax hub, of the two-sided platform concept, but now in relation to developed countries, can be seen in the Prevost case decided by the Canadian judiciary. Here, a joint ventures of a Swedish and UK MNEs set up an intermediate entity in the Netherlands as a gateway to Canada as a market jurisdiction that allowed these joint ventures of MNEs to substantially minimize the withholding taxes on dividends remitted from Canada to Sweden and the UK via the Netherlands. So I think this concept of two-sided platform can be helpful in order to understand the logic of the tax hub market in both the developed and developing countries. In terms of the theory, so this paper offers a theory of global tax hubs to explain key driving forces accounting for the creeping marketization of the international tax system, particularly since the 60s. Tsilly Dagan, I think, was probably the first scholar to openly talk about the marketization of the international tax system. She developed that concept in her seminal book, published by Cambridge University Press. And as soon as I read that paper, I wanted to somehow further explore Tsilly's concept of marketization of the international tax system. And this paper is an attempt to understand more about that concept, I think, or I hope. My theory for your consideration is the following. I think the global tax hub market is a non-collusive oligopoly of two-sided platforms offering matching services between multinational enterprises and market jurisdictions in pursuit of a compensation functionally equivalent to a fee. I say that this is a non-collusive oligopoly because they are not, they don't have a club of tax hubs. They are not coordinating their interest explicitly. It's, I think, an implicit coordination of interest in order to maximize their profits and their tax rent. And that is why I think that the strategic structure of Uber and the tax hub market are fundamentally the same, in the sense that while Uber is out there in order to match car drivers with passengers, I think the tax hub's role is fundamentally to match MNEs with market jurisdictions, particularly since the United States and the UK introduced check-the-box regulations in 1997 and 2013, respectively. In terms of the findings, I I would like to identify 5 elements. The first finding is the following. I think the two-sided platform seems to be an illuminating concept to explain the frequent business model used by tax hubs on all continents. I'm not saying that it is the only the sole business model. I'm saying it is one important business model used by tax hubs. According to recent data by the UN and the OECD, about 30% of all FDI is normally channeled through tax hubs. And what is striking is that after BEPS 1, that percentage has increased rather than decreased. And I think that the Andolan and Prevost cases in India and Canada, respectively, are illuminating examples on the explanatory power of the two-sided platform concept. In order to ground this first finding, I would like to say that all fundamental elements of any two-sided platform, I think, are present in the tax hub market. For example, it has a clear mission, users, and feedback. It is possible to find cross-site network effects, same-site network effects. There are 2 distinct users' demands by MNEs and by market jurisdictions. It is offering a vehicle for minimizing search costs. There is an entry and usage fee and failure of the cost theorem. And it is possible to see platform competition and since the 90s, multi-homing. That is to say, it is possible to see that in the very same tax planning, a given MNE is using more than one tax hub, as it can be seen in, for example, the Apple Ireland case, in which the Netherlands, Ireland, and other tax hubs are used in the same tax planning. The second finding is that I think there has been a global transplant of this business model from Europe to the rest of the world. So global tax hubs were based only in Europe in the 60s, and since the 80s, they have expanded to all continents. This geographical expansion is correlated to, I think, 3 external shocks that probably have reduced the entry cost of jurisdictions to the tax hub market. The first element is a deregulation of the global financial market since the Reagan and Thatcher administrations in the 80s made capital increasingly mobile worldwide. The second driving force of the expansion of this tax hub global market is the following: the invention of new communication technologies such as the fax and then the internet materially minimize the communication cost between the different units of MNEs, including their intermediate entities based in tax hubs located in remote jurisdictions. And finally, the introduction of regulations such as the check-the-box rules in the US and the UK in 1997 and 2015, respectively. What is fascinating is to see that the UK, I think, transplanted the check-the-box rules from the US via a decision of the UK Supreme Court in the Anson case. So this expansion can be inferred from the fact that the tax hub market consisted of fundamentally 2 European jurisdictions in the 60s and later increased to 13 jurisdictions from 4 continents in the 2000s. And this global expansion can be seen in these couple of slides. I mean, this is the 60s, the yellow submarine era. As you can see, all tax hubs were fundamentally in Europe, particularly Switzerland, the Netherlands, and Belgium. And in the 2000s, this business model has expanded to virtually all continents. Even in remote locations such as, since this is a global audience, nothing is remote. But if you see, I mean, US multinationals with an intermediate holding company in Singapore is an example of what I mean. The third finding is that there has been an increasing tax hub platform competition. Multi-homing is a case in point. Indeed, while most disputed tax planning structures involve one tax hub in the 60s, an increasing number of tax structures since the 2000s involve more than one tax hub. The use of intermediary entities based in Belgium, Hong Kong, and Luxembourg in the TK case in South Korea, I think, is a telling example of multi-homing. That you say the use of more than one tax hub in the same structure. So I think multi-homing may signal growing competition within the tax hub two-sided market to become the most relevant tax hub or joint ventures of tax hubs in, for example, a given industry and market jurisdiction. These couple of slides, I think, show this increasing competition. In this slide, this is once again, we are in the yellow submarine era. We are in the 60s. The first column represents G20 countries, such as Germany. The second column represents non-G20 hubs, prominently Switzerland. The third column represents topic of disputes, for example, PE conflicts. And the fourth column represents the outcome of those disputes, so who prevail in those disputes. So what we can see is that, okay, a substantial portion of the conflicts emerging in the 60s involve Article 5 of the OECD model, that is PE conflicts. And in a substantial volume of cases, the taxpayer was able to prevail. So these cases are involving, for example, Belgium and Germany. Now, if we move to the 2000, we can see that the number of tax hubs has increased dramatically, probably because of the three reasons I identified, particularly the introduction of the check-the-box rules in the UK and the US. The volume of disputes also has increased dramatically. And one quite relevant type of dispute emerging in the 2000 is transfer pricing here. And we can see that the taxpayer was able to prevail in a substantial percentage of those cases. So here, transfer pricing disputes involving, for example, Luxembourg and India. The fourth finding is the point according to which tax hubs is a non-collusive oligopoly, according to the theory submitted in this paper. The global tax hub market is probably a non-collusive oligopoly for at least the following three reasons. The first reason is that it is a growing but still relatively small market offering a similar matching service to similar users, that is, say, MNEs and market jurisdictions respectively. As discussed, this market consists of just 13 jurisdictions in the 2000, according to my definition of tax hub. The second reason is that tax hubs do not explicitly coordinate their interest. The coordination between tax hubs is implicit. Tax hubs are not a cartel because there is no institution functionally equivalent to the OPEC in the global tax hub market. And finally, tax hub seems to be involved in a co-opetition game. That is, they may be willing to implicitly cooperate with competing tax hubs in certain areas. Playing the role of amicus curiae, supporting the position of competing tax hubs in tax litigation is a prime example. For example, Luxembourg is submitting an amicus curiae in the Apple Ireland case involving state aid law. The final finding is the following. International tax enforcement by G20 countries. Here the question is, to what extent is there a logic of strategic defection? A telling example of tax hub disruption on the ITR stability is the following. In the 60s, G20 countries focused the enforcement of their international tax system on non-G20 hubs to protect their international tax base. So, for example, it is frequent to see Germany litigating against Switzerland in the 60s. However, this international tax enforcement pattern gradually changed in the 70s, 80s, and 2000 as G20 countries focused their enforcement effort on other G20 countries rather than on non-G20 hubs, presumably to maximize the attraction of the FDI. So it was increasingly frequent to see France litigating against Italy rather than against Monaco. This change in enforcement presumably induced MNEs to get into market jurisdictions like G20 countries via certain non-G20 hubs rather than G20 countries. This MNE pattern of using tax hubs as low tax gateways to market jurisdictions has probably been further strengthened because MNEs have been able to prevail in over 53% of leading tax treaty disputes involving non-G20 hubs before G20 courts since the 2000. So one potential problem I could deal with my two-sided platform concept is the following. How could we explain the emergence of disputes between G20 countries and non-G20 hubs? And I think that tax disputes between market jurisdictions and tax hubs are a redistributed game compatible with the two-sided platform model. So a similar thing can be seen in the Uber context. A similar dynamic also occurred in Uber when car drivers started to litigate against Uber to get benefits of employees' status, such as holidays, pension contribution, etc. The point here is that a similar logic may explain why, for example, France might be willing to litigate against a tax hub. A potential explanation is that France might not be happy with the redistribution of the tax rent between France and Monaco, so it wants to somehow start a redistributed game, similar to what we see in Uber. The next almost final point is what could be the policy implication of this theory on the emerging international tax regime. The two-sided platform global tax hub market has a deeply rooted incentive, I think, to exacerbate the ITR mobility problem by inducing opportunistic behavior on the part of both MNEs and market jurisdictions. So this paper aims to show that these three players are involved in the same business model, so their interests are somehow aligned. Hence, I think the new international tax regime should include a policy to make the behavior of the three oligopolies as transparent as possible. For example, by way of an external mechanism for monitoring the behavior of tax hubs, market jurisdictions, and MNEs when enforcing key elements of the new international tax regime. I think that the recent EU Parliament decision to make country-by-country reporting public is a promising way forward, provided it is adopted by all G20 jurisdictions because most MNEs are headquartered there. So as a conclusion, I would like to say the following. So this paper aims to offer what I think is the first available theory of global tax hubs as a network market. It shows that multinational firms, tax hubs, and market jurisdictions play different yet interrelated roles in the same business-like model, that is to say, the two-sided platform. It argues that tax hubs are like the Ubers of the international tax regime. The theory aims to explain how this creeping marketization of the ITR has been frequently instrumented worldwide, particularly since the 60s. It also aims to explain why this business model has been disrupting the ITR stability. And the theory grounds a policy proposal on the emerging new international tax regime that is presented in this paper and inspired by recent EU law. Thank you so much for your attention. And now I'm looking forward to Tsilly's feedback. Thank you.
Thank you very much, Eduardo, and for such a complex set of theoretical combinations. You stuck perfectly to time, so I'm extremely impressed. I have lots of questions because the series is pretty challenging for me, not having read most of it, to be frank, and to sort of think about the way you're reasoning about rent, tax rent, and about this new way or different way of thinking about the role of havens, essentially, which we could think of as, yeah, kind of legal and geographic intermediaries in some ways. So that idea of these as analogous to platforms in the digital economy. But I'm going to pass to Tsilly. She can have first go at the questions and comments, and then we can open it up. Thank you so much, Tsilly.
Thanks. So thanks so much, Miranda, for inviting me, and thanks, Eduardo, for this paper. I had such a good time, engaging with it, and there was a few who haven't had the chance to read it. I strongly recommend that you do, because I truly think it's worth the effort. So this paper is actually, as I told Eduardo before, a 3-in-1 deal. It has a theoretical two-sided platform analysis of the role of hubs that Eduardo has explained. It has an empirical overview of the evolution of the regime, and it has a critique of Globi, analyzing Globi as an unstable equilibrium due to the inherent incentive to disrupt it by hubs. But since my time is limited, let me focus on the first and the third points of the paper. So I found Eduardo's description of hubs as two-sided platforms highly convincing, and his analysis of both the characteristics and the implications of such a platform, both insightful and illuminating. I share, as may not come as a huge surprise, I share Eduardo's strategic approach to international taxation, and like him, I tend to analyze the international tax system as a market, and to look at countries as strategic actors competing for investments, for residents, and for tax revenues. Platforms are indeed, as Eduardo has argued, a prominent type of network markets. Platforms play the role of matchmakers, allowing network participants to come together by reducing transaction costs and by allowing for value-creating transactions to take place. So we have multinational enterprising seeking to invest it on the one side, and on the other side, we have market jurisdictions seeking M&E's investments, but facing barriers in the shape of taxation imposed. And hubs are here to help and reduce those costs by minimizing entry and exit costs, as Eduardo nicely explains. My first question is very technical, I guess. Eduardo, you described market jurisdictions as production and consumption states. And I may have missed this, but are residence countries part of your story explicitly as a typecast? Now, Eduardo argues that this feature of hubs is problematic, that tax hubs are disruptive of the international tax regime's stability. Disruptive because they exacerbate the problem of mobility, what Eduardo called the Achilles heel of the international tax regime. So the first point I would like to make today focuses on mobility. Is facilitating mobility a problem? Is reducing transaction costs something that the hubs are actually doing a problem? And if so, why? Now, ordinarily, we would say that reducing transaction costs is a virtue as it promotes efficient transactions. The same is often probably true about mobility. The problem in this case is that these transaction costs are not just any transaction costs. A great part of them are taxes. So the question is really, are taxes different than any other transaction costs? Reducing reducing taxes under tax competition is not necessarily a problem. So think, for example, of the alleviation of double taxation. It too is a reduction of transaction costs that facilitate mobility. Moreover, tax competition also serves to control excessive governmental expenditures or corruption as under the Thibault model. The problem starts when tax competition drives tax costs below some ideal. But what is this ideal? It's very hard to determine. If we limit ourselves to economic efficiency alone, this ideal would probably be the cost of providing an optimal level of public goods, such that the public is actually interested in, and that collectively providing them is cheaper than for each and every one of us to provide them on her own. Under the Thibault model, an efficient market could be very helpful in sorting out this question. When taxpayers vote with their feet, selecting the preferred package of goods and services. However, taxes, as we all know, are not only about paying for public goods. They're also about justice, about the allocation of the costs of public goods and benefits, and about redistribution. And mobility is tricky in that sense, because mobility is not distributed evenly among constituents, and definitely not between constituents and multinational enterprises. In other words, some taxpayers and some resources, notably capital, are way more mobile than others, making their choice of residency and their ability to opt out of the jurisdiction by way of tax planning a lot easier than for others. Hence, tax policies become more about elasticities than about equality. Now, why is this a problem? Well, because for the mobile, a pricing mechanism under the Thibault model works very efficiently. They get what they pay for, and that's great. However, for the immobile ones, that means reducing the level of public goods and services, sometimes to an unacceptable level. To put it simply, countries still need some level of taxes to be collected to provide for the public goods and services of the immobile and redistribution in particular. So tax competition facilitated by hubs is good only up to a limit. If it curtails excessive costs of government or limits corruption and facilitates choice beyond an essential level of the welfare state, that's great. But if it threatens to undermine the sustainability of states' infrastructure for providing security, health, and welfare of its constituents, that becomes a problem. The problem is that hubs have no interest in securing some such basic level of taxation. They are in the business of raising taxes to the unlimited bottom. Other states, especially residence countries, on the other hand, may wish to be able to raise taxes for the sake of their entire population. Hence, they may have an incentive to get together and cooperate in setting a floor for their taxation, as Globe did for corporate taxes, or did is probably an overestimate, is doing, let's put it this way. Host countries too may benefit from collecting tax revenues if the threat of capital shifting away would have been removed. But that is not necessarily a positive thing per se. To use the Uber example, drivers may benefit from increased prices, but that doesn't necessarily mean or isn't necessarily something we would like to encourage. The point where it starts to become necessary to limit the taxes of hosts racing down and hosts racing down taxes is in cases where, for example, for strategic reasons, they outcompete one another to a suboptimal level, as competitors sometimes do when they are trying to drive one another out of the market, or when they are locked into a prisoner's dilemma. But that perhaps is for another paper to keep building on the industrial organization literature. So what's the solution? The international tax community is moving forward on a cooperative solution where countries, resident, source, and market countries will cooperate to reestablish their tax prices despite hubs and multinational enterprises' activities. Coordinating such a compromise is, of course, highly complex, as we're seeing these very days. But in principle, it hits the right note. Will it succeed? Not sure. It is indeed a cartel and as such inherently unstable. And the history of the last few decades does not offer much encouragement. That is because the calculation of at least some countries is that they would be better off undercutting other countries to attract more inward investment. This has been pretty good policy for hub countries such as Ireland, for example, for many years. And as Eduardo notes, the result has been a steady fall in tax rates. What may be different this time around? Perhaps the fact that strong countries, notably the US, lead the proposal. Perhaps that may make a difference. Perhaps other countries will now see more benefit from potentially higher revenues than from competing for investment. What may also be different now, and Eduardo alludes to this in his paper, is the threat of punishment. The undertax payment rule, according to which there should be restrictions on allowing costs to be deducted from tax, where those costs involve payments into countries that are not part of the system. The jury is still out, of course, on whether the framework will indeed be up and running in the near future or anytime soon. But even if it is successful, this framework may not offer a long-term stable solution. As Eduardo notes, at some point, countries are likely to reconsider the trade-off between revenue and investment, and some may be tempted to defect from the agreement. Just as with the current system, and just to be frank, with any cartel evolving and aiming to keep prices high, there will always be some incentive for some countries to defect from the deal. But even if GloBE is successful, I would like to extend the network analysis and shed light on another strategic problem, and that is the following. GloBE, too, is a network in itself built on a compatible standard. That is, in their attempt to build the cartel and reinforce it, OECD countries offer a compatible standard. Now, Eduardo is skeptical about the success of this standard due to the incentives of participants to opt out, and I don't disagree. But this is where the network structure could be useful as a cooperative enhancing mechanism. The network effect that Eduardo describes in this paper works here to entice countries to join the network and stay there. This is the process we're watching right now. The question is whether the OECD proposed standard will be able to take over the market and become the only game in town, or at least the only game which important countries play. If that's the case, then countries will stay in the network just because other countries are staying in it. Because the benefits of belonging and hence not being subjected to the UTPR and losing tax revenues are greater than the alternative. If the network is successful, it raises a whole new network problem. Eduardo mentions the locking effect as one of the key problems with networks, and I agree. The current regime, if successful, may stay with us for a long time, even perhaps too long. And that is even if its results are inferior to other potential models. And this is simply because it is very hard to turn this ship around due to the lock-in effects. But there is another important negative feature of networks that has to do with standard setters. So think of Microsoft as an example. Standard setters or standard owners can raise prices if they take over the market. This is not so much a problem with Uber thanks to its competitors, but the international tax community, unfortunately, is not rich with alternatives or with alternative competing standards. And if and when the OECD standards do take over, its owners, that is OECD countries, will be able to raise their prices and pursue their own interests at the expense of other countries. So what can we learn from network theory for the future? Eduardo claims that a detection and punishment mechanism are needed. I can see why. But if we were serious about designing the international tax market as a sustainable, efficient, and fair mechanism, what can we do about the excessive power of OECD standard setters. Eduardo mentions at the beginning of his paper antitrust as a mechanism that could help. And he knows that I'm sympathetic to the idea. Could mechanisms based on antitrust law help us in building a better international tax regime? Can we do this without some kind of global governance? If we could resolve this, great. But if not, are we left with a hard choice? In other words, which evil is worse? Excessive power of OECD standard setters or the incentive to raise tax rates to the bottom through competition? Thank you.
Thanks very much, Tsilly. Yeah, very interesting. Eduardo, you're sharing your screen, I see.
Yes, I will try to, yes.
You just want to come back. So would you like to then make a couple of responses before we open up? So I'm conscious that we have a question in the chat, and I'm sure people would like to pursue Q&A. So yeah.
Thank you very much, Miranda. Thank you very much, Tsilly, for your wonderful questions and comments. They are very illuminating. Let me start with something that I think is implicit in your comment, Tsilly. I think there is a fundamental problem in the governance of the international tax regime, because I think the system is fundamentally controlled by these three oligopolies: MNEs, market jurisdictions, and non-G20 hubs. These are the owners of the OECD technology in normal times. In tragic times, it is possible to see an emergence of a fourth one-day oligopoly, tax NGOs, suggesting something unexpected, the country-by-country reporting that is being accepted by the three oligopolies. But I think what we really need, for God's sake, is to do something in order to create a fifth stable oligopoly of developing countries and emerging countries that are not represented in this game. So the big question is, how on earth can we create a fifth oligopoly? And why don't we think about a concept that I take from antitrust law, which is the concept of clustering. So when we talk about developing countries, we are talking about a huge group of countries, probably over 100 countries. So they are too many to coordinate. So what if the OECD or the UN do something in order to induce developing countries to cluster before going to Paris to negotiate with the other three oligopolies? So, for example, African countries may get together before flying to Paris in order to see what they want from this regime. When you were talking about this fundamental problem, I was thinking of Ireland, when what is now the Republic of Ireland was not represented in the UK Parliament. Of course, the interests of Irish people were underrepresented, and they suffer a lot because of their underrepresentation in the UK Parliament. So my point here is that developing countries are in the international tax regime what Ireland was when it was part of the UK and it was not represented in the UK Parliament. They are underrepresented. So that's my first point. We are dealing with a fundamental governance problem because one substantial number of countries are simply underrepresented. And my suggestion here, if we want to try the cooperation model, would be to induce developing countries to cluster, to create clusters. So African countries, for example, Latin American countries could be another cluster, etc. That they could negotiate, agree on what they want before flying to Paris to meet their demands. That's my first point. The second point is, yes, when I talk about production and consumption as an important definition for market jurisdictions, I am assuming, I don't know if this is correct, that they are largely a country of residence, according to the regular wording used by international taxation. My last point is what BEPS 1 and BEPS 2 are actually doing within this network market framework. My short answer to that would be that BEPS 1 is substantially increasing the substance requirement. So if a given MNE wants to minimize its reputational cost and litigation cost emerging from using tax hubs, they have to have substance in the tax hub. So probably the winners of this substance requirement encapsulated in BEPS 1 are the well-established tax hubs such as Switzerland, Netherlands, and Belgium, where there is already a lot of substance, vis-a-vis Panama and Bahrain, where there is quite little substance. And what is BEPS 2 actually doing, as far as I can see? Okay, Pillar 1 is fundamentally expanding the market jurisdiction the market countries' tax jurisdictions, because they now have a relatively larger bargaining power vis-a-vis the oligopoly of MNEs and the oligopoly of tax hubs, because of the context of the pandemic and global financial crisis that somehow has been expanding the leverage of the oligopoly of market jurisdictions vis-a-vis the other two oligopolies. And what is Pillar 2 doing? Okay, with this minimum global tax system, I think Pillar 2 is trying to limit tax competition in the entire system. So Pillar 2 applies to the three oligopolies. It's an attempt. If that fails, I think Tsilly is right in her chapter 7 of her seminal book, when she suggests that if the cooperation model fails, we will probably have to move to a competition model in which antitrust laws could be relevant in order to improve competition between countries in the area of taxation. I hope this answers some of your concerns, Tsilly and Miranda, and thank you very much.
Thanks, Eduardo.